Welcome to week 8 of the course. This is the last of the chapters which we are dealing, the very important and interesting chapter on settlement and enforceability of the mediation settlements. We have hitherto had discussion on what is mediation, why mediation, how mediation, why and how it is important for conflict resolution, and also understood the concept of communication, how it is relevant. We also had exercises on communication, understood what is conflict, what is dispute, what is conflict resolution, how to manage the conflict. Now we have come to the last stage of the mediation course, namely the settlement under mediation and how to effect or execute a mediation settlement. First we have to understand the process of mediation. Mediation settlement happens at the last. That is to say, the mediation begins with the mediator welcoming the parties to the mediation room. He has the introduction. He also gets the introduction of the parties. Then thereafter, the opening statement starts, where the mediator makes the opening statement. We have the joint session. Then we have the private session, or could be several private sessions. And thereafter, when the parties are moving from dispute to resolution, if the parties are moving in the positive direction and they are going into the process of resolution, then the last item before the closure is settlement. It need not always be ending in a settlement. We all know that most of the disputes may get resolved and the parties may want the mediator to prepare the settlement, what we call it as a memorandum of settlement. It could be that in some of the cases there is no settlement possible because the parties are not able to agree to agree. In such cases, the question of settlement does not arise. Therefore, drafting of the settlement does not arise. We can call it as conclusion. In such cases where the matters get concluded, maybe the mediation is not successful or mediation is not resulting in a settlement, yet it's a conclusion. In such cases, the mediator at the time of conclusion thank all the parties and thank them for having been very patient, having had the faith in the system of the mediation, and having tried their best to resolve the dispute, and thank them and leave the entire mediation with a happy ending or with a positive note. That would be as far as conclusion is concerned. Now the settlement. The settlement has certain parts. The settlement part has to be understood that the mediator has to prepare the settlement. The mediator has to draw the settlement. So to understand what is settlement, how it can be arrived in the mediation, we have to have some basic knowledge of law. It is necessary that we should understand the basic concepts of law, more particularly the law resulting to the drawing of the settlement and as to the nuances required to be followed when drawing such settlements. With that in mind, we'll now get into this. The mediator has to have the basic knowledge of what is the nature of the dispute which is referred. There are varieties of cases which could be referred to mediation. The first one is called the court-referred mediation. What do you mean by court-referred mediation? It's a mediation which is referred to in a pending matter in the court. That is to say, it's a post-institution mediation. The institution being the court. So the matter is already in the court. Maybe A has already approached the court, filed a dispute. B, the opposite party has appeared, and both the parties having appeared in the proceedings, the judge has referred the matter to mediation. Such disputes referred to mediation are called as court-referred mediation. These are usually matters which are referred to the mediation center by the respective civil court. Mediation can be tried in disputes which are civil in nature under the provisions of Section 89 Code of Civil Procedure. So such matters are post-institution mediations or court-referred mediation. The court would have referred this matter to mediation at any point of its proceedings. It could be at the beginning when the trial has not begun, or it could be in the stage when the trial between the parties, the evidence between the parties was underway, or it could be at the stage when the parties are already in the argument stage, or it could be sometime before the judgment is delivered. The court, namely the appellate court, where the first round of litigation is completed and one of the party who has felt aggrieved has approached the appeal court, in that proceeding too, the matter can be referred to mediation by the court. It can be at the instance of the court, namely the judge, or by the parties requesting the court. It also could be in the second round, what we call it as second appeal, that the matter is also referred to mediation by the court. So court at any point of time during the pendency of its proceedings can refer its dispute, a pending dispute which is before it, to mediation in the interest of finding solution. It could be that the judge finds that there is an element of settlement possible and therefore he refers the parties to try and resolve and explore mediation. So this is called as court-referred mediation. When we say court-referred mediation, certain provisions of law we have to be aware of. Namely, the first thing is the Code of Civil Procedure 1908. It's a procedure which is adopted in the court, and the mediation also, when it comes to drawing a settlement, the mediator has to have the knowledge of Code of Civil Procedure 1908. It has certain provisions which are relevant to the jurisdiction and settlement, etc. That we will deal one by one now. Section 2, subclause 2 of Code of Civil Procedure deals with the word decree. Decree has been defined under section 2(2). It means a formal expression of an adjudication which, so far as regards the court expressing it, conclusively determines the rights of the parties. This is important. In other words, decree is a final order passed by the judge giving the judgment and giving and deciding the rights of the parties. Section 2, subclause 14 deals with order. This also we have to be aware, because there is difference between order and decree. There could be several orders in a proceedings, but there could be probably one final decree. There cannot be more than one final decree. However, there can be any number of preliminary decrees. Pecuniary jurisdiction. It is dealt in section 6. Pecuniary jurisdiction is a jurisdiction where the limit of the court is defined. That is to say, the court, namely the civil court dealing with the disputes, has its pecuniary limitations. That is to say, in such cases, the limit, if it is described as 10 lakhs, the disputes which are having a subject matter with valuation more than 10 lakhs, that court cannot take it. It can only take the disputes less than the value of 10 lakhs. We should also know that the courts have territorial jurisdiction. Defines that every suit shall be instituted in the court of the lowest grade competent to try it. That is to say, a dispute has to be filed in a competent court of the lowest grade. There are different grades of court, and that has to be understood. There is civil judge, junior division, civil judge senior division, district judge who heads the district, then there is high court, then there is Supreme Court. This is the hierarchy of the court. So when we say it is the lowest grade, it is a civil judge junior division level court. Or if some dispute is to be lodged in a court, namely civil judge senior division, that would be the lowest grade where the dispute could be lodged. Section 16, jurisdiction of the property where it is situated. If it is to say that the property is an immovable property and the dispute is pertaining to the said immovable property, the jurisdiction where the immovable property is situated, and that jurisdiction only, that is to say the court of the said jurisdiction only, the dispute can be filed. For example, if the dispute is in the district of Nasik and the parties are wanting to file dispute against each other, the one who wants to file the case, namely the plaintiff, will have to approach the court which has the jurisdiction of Nasik, and that court only he can file. He cannot file it in other districts because the territorial jurisdiction of such case is Nasik. Section 17. This is also continuation of section 16. If there are properties involved in different jurisdictions, namely before courts which have jurisdictions in different areas. For example, Nasik is one where it has a property, and the other property involved in the said dispute could be in Indore. So in such cases, the person who wants to file the case can file either in Indore, that is to say the jurisdiction of Indore, or before the Nasik court. He can choose the forum either between Nasik and Indore. Section 19 deals with the jurisdiction in respect of monetary claims or compensations, that is to say where it is not an immovable property. In such cases, it is the defendant, namely the opposite party. The one who files the case is the plaintiff. The one who is on the arrayed as the opposite party by the plaintiff is the defendant. And the jurisdiction of the court to where the dispute has to be filed is decided on where the defendant is carrying on his activity or his business. In all other cases, Section 20 decides the jurisdiction, that is to say where the defendant resides and carries on his activity, that would be the jurisdiction. That's Section 20. While being a mediator in respect of civil disputes, one should be also aware of the law of limitation. Limitation Act 1963. Every dispute has a time limit. A person who has to file a case has to decide and file the case usually within a time limit of 3 years from the date of the cause of action. What is cause of action? We will deal it with little later. So the Limitation Act gives the limitation period to file the case. We will assume that a dispute has arisen between two parties. Party A, namely the plaintiff, has to approach the court within the said period of limitation as defined under the Limitation Act. We will assume for the sake of understanding that the period of limitation is 3 years. The party A, the plaintiff, has to file the case within 3 years from the date of the cause of action for the filing of the case. Suppose the cause of action is 2009, then the case before the appropriate civil court has to be filed within 3 years from the date of 2009. Now coming to the cause of action. Cause of action is an event which has caused the party to file the dispute. It can also be understood as it's a bundle of events which has happened, or the events which have taken place in the dispute between the parties. We'll take an example of a recovery dispute. We'll assume that A has lent money to B and he has got executed a pro note, on demand promissory note. The date of the promissory note is 10/10/1999. The payment has to be made by the defendant, the person who has borrowed the loan, within 3 months. 3 months from the date of 10/10/1999, the date when the promissory note was executed. If the defendant has not paid the amount as promised within 3 months from 10/10/1993, from that day, within 3 years, the dispute has to be filed. And the cause of action for filing the case is the date when the promissory note was executed. 2, the date when the defendant ought to have paid as he had promised to pay. 3, when the defendant denies to pay. These are called as bundle of events which has caused the plaintiff to file the case, namely the cost to file the case. Therefore, it is called as cause of action. The next provision which has to be understood for the purpose of execution of the decree is Order 21 of Code of Civil Procedure. This in detail explains the nature of executions possible to recover. This would arise after the decree is passed, namely the court has passed the decree, and if the person who has promised to honor the decree by making necessary compliances as required under the decree, if he has not followed it. Now we will go a little deep into this. Mediation has been successful. The parties have found a solution in a court-referred mediation. The parties have had a memorandum of settlement, which settlement has been recorded, wherein there are certain promises which have been assured by the defendant, and the said promises have been not followed by the defendant, and the matter, the memorandum of settlement has already become final, signed by the parties, and it has amounts to a decree. And once the decree is passed, if the defendant has not honored the promise or he has disobeyed the undertaking given, then the party has to approach the court, namely the plaintiff who has filed the case. He becomes the decree holder of the decree. He has to approach the court and seek execution of the decree, namely the amount which is under promise under, namely the amount promised under the memorandum of settlement under Order 21 Civil Procedure Code. Mediation settlement has to be drawn according to law. How it has to be drawn, where it has to be registered, who has to record the settlement is provided under Order 23 Civil Procedure Code. Now coming to the other aspect. A mediation settlement has been drawn in a court-referred mediation. The settlement will be a formal settlement which are signed by the parties in the dispute and their respective advocates. It won't have the sanctity of law till such time the matter which is settled is referred to the court, namely the referral court. The referral court examines the memorandum of settlement entered into between the parties, finds whether they are in order, whether they are within the four corners of law. Once it is satisfied that the memorandum of settlement signed between the parties is proper, appropriate, and under the provisions as required under law, namely Order 23 Civil Procedure Code, it passes an order of confirmation of the settlement. It becomes a decree only then. That is to say, a court has to pass a final order on the memorandum of settlement. It has the legal sanctity of a decree and it can be enforced by the party who requires the enforcement to see that the memorandum of settlement, the terms therein are honored by the defendant. Therefore, mediator has to be acquainted with the law applicable and draw memorandum of settlement in terms of the understanding between the parties. The Consumer Protection Act 2019 has undergone an amendment. By Act number 35 of 2019, certain provisions have been included, certain chapters have been included in the Consumer Protection Act 2019. A dispute which is filed before the consumer forum, that is a district consumer forum, state forum, or the central forum, that is national forum, if any party intends to try and explore mediation, the Consumer Protection Act 2019 provides for that. Chapter 5, Section 80 and 81 are the provisions which govern the mediation and the procedure for settlement of mediation in Consumer Protection Act. Section 2, subclause 6 defines as to what is complaint. 2, subclause 7 defines who is a consumer who can approach the Consumer Protection Act and file a case under the Consumer Protection Act. Section 2.8 defines as to what is a dispute, a consumer dispute. 2, subclause 9 defines consumer rights. What is the defect for which the party can approach the court is defined under Section 2.10. Deficiency which necessitates a party to approach the court, namely the Consumer Protection Court, Consumer Forum, is defined under Section 2.11. 2.12, design. Chapter 5 defines the mediation under the Act. Section 77 defines the duty of mediator. Section 79 defines the procedure of mediation. Section 80, settlement through mediation. In other words, consumer disputes referred under the Consumer Protection Act 2019 are also court-referred mediations insofar as consumer disputes before the consumer forum. The provisions of settlement of the dispute, as similar to Civil Procedure Code, is also provided in the very self-contained act, namely the Consumer Protection Act 2019. These are the provisions which have to be kept in mind while drafting the settlement under the consumer disputes. Section 81 gives as to what is recording of settlement, how it has to be recorded. Hitherto, we had dealt with court-referred mediation or post-litigation mediation. Now, we will deal with pre-institution mediation. Pre-institution mediation is a concept under the Commercial Courts Act 2015. Commercial Court Act 2015 defines certain disputes. They are provided under Section 2(1)(c) of the Commercial Courts Act. To name a few: ordinary transactions of merchants, bankers, financiers, and traders, such as those relating to mercantile documents, including enforcement and interpretation of such documents; disputes pertaining to export or import of merchandise or services; transactions relating to aircraft, aircraft engines, aircraft equipment and helicopters, including sales, leasing and financing of the same; carriage of goods; construction and infrastructure contracts, including tenders; franchising agreements; shareholder agreements; technology development agreements; agreements for sale of goods or provision of services; insurance and reinsurance. These are some of the disputes out of the 21 named therein. Such disputes, if any, arises during the course of transaction between the parties, then the party cannot directly approach the court for remedy except under certain circumstances. The party, namely the plaintiff, has to explore the mechanism of mediation before attempting to file the case before the commercial court of the jurisdiction. In other words, mediation prior to filing of the institution of the dispute before the commercial court is necessary. It is compulsory. A disputant cannot directly approach the court and file a case except under certain circumstances, when he requires urgent and immediate orders from the hands of the court. Otherwise, any commercial dispute, the disputant has to first approach the mediation, explore the possibility of a settlement in the mediation, and if the mediation is successful, then the question of filing the dispute before the court doesn't arise. If the mediation is not successful and the party who has approached the mediation, the pre-institution mediation, has not got the desired result, then only he can approach the commercial court of the jurisdiction and file the case. This is pre-institution mediation. The difference between the present pre-institution mediation and the earlier one is, in the earlier one, namely the court-referred mediation, the litigation is already lodged and then the mediation begins thereafter. Here, the mediation begins even before the litigation, and the litigation is optional. If the party who has approached the litigation, if the party who has approached the mediation does not find a suitable remedy, then only he can approach the commercial court. The mediation under the Commercial Courts Act 2015 is governed by Pre-Institution Mediation and Settlement Rules 2018. One another matter which has to be kept in mind while approaching the commercial court is the subject matter of the dispute, called as specified value, shall have to be more than 3 lakhs. That is to say, the remedy which the party is intending to seek from his opposite party, and if a dispute is a commercial dispute as defined under section 2(1)(c) of the Commercial Courts Act 2015, the specified value has to be more than 3 lakhs. If it is less than 3 lakhs, then the commercial court does not have jurisdiction. Therefore, the pre-institution mediation is not applicable. In other words, if the specified value is less than 3 lakhs, such party need not go to the commercial court, nor he need to apply for the pre-institution mediation. He can always approach the civil court, which has the jurisdiction, and seek the remedy. Please note, when you say civil court, the mediation is only after the filing of the suit, and when you say commercial court, it is before filing of the case. Let us have few examples of the disputes which can come before the commercial court. A and B are partners. They run a partnership firm. After few years, they have some disputes between them. The partners want dissolution of the firm. The dispute has now arisen between them. They are not able to amicably resolve between themselves. The said dispute is a commercial dispute under the Act. Therefore, such partners who have difference of opinion, who want to file a dispute before the commercial court, shall have to first file an application for pre-institution mediation. A is a service agent. He maintains the apartment complex. He provides for security. He maintains and cleans the apartment common areas. He provides for other services for maintaining cleanliness of the apartment complex. He enters into an agreement with the apartment owners to maintain the apartment and receive maintenance fee from time to time on monthly basis. Where there is a dispute on one side by the apartment owners with the agency which is maintaining the apartments. This is a commercial dispute. If the subject matter, namely the specified value of the amount which is in question, which is sought to be recovered by the agency from the apartment owners, is more than 3 lakhs, then in such cases he has to file a pre-institution application for mediation and explore mediation. If the mediation is successful and the matter is resolved, then there is no need for the agency to approach the court. In other words, the whole object of Commercial Courts Act 2015 is to save the litigation and to see that there is ease of doing business. The whole idea is to see that the parties mediate first, and if only they are not successful, then they go to the court to litigate.